Tenant rights violations in Canada. In Canada, tenants have rights that landlords must respect, and violations of these rights can lead to legal recourse. These violations can include illegal entry, harassment, discrimination, failure to maintain a habitable living space, and improper eviction procedures. Tenants can seek remedies through the Landlord and Tenant Board or other relevant tribunals, and in some cases, through human rights commissions. Common tenant rights violations. 1. An illegal entry. A landlord must provide proper notice before entering a rental unit, except in cases of emergency. A violation of the law is entering without consent or for unauthorized purposes. 1. Landlord right to entry. Typically, landlords have the right to enter a rental unit for specific reasons, such as inspections, repairs, or showing the unit to potential buyers or mortgagees. 2. Notice requirements. In most cases, landlords should give tenants proper notice before entering their units. 3. Reasons for entry. A written notice should include the reason for the entry, the date of the entry, and the time of entry. 4. Exceptions to the rule. An emergency can include a fire, flood, a burst pipe causing flooding, a gas leak, or any situation that poses an immediate threat to life or property. 5. Tenants' consent. In addition, landlords can enter without notice if the tenant explicitly consents at the time of entry. 6. Consequences of illegal entry. The Landlord and Tenant Board can investigate illegal entry, take legal action against the landlord, and impose financial penalties. 2. Harassment. It is illegal for landlords to harass, threaten, or obstruct tenants, or to interfere with their reasonable enjoyment of the leased premises. There are many forms of harassment, including intimidation, threats, or unwelcome advances. By making discriminatory comments or actions, a hostile environment can be created. 3. Unreasonable interference with quiet enjoyment. The term refers to any substantial interference with a tenant's peaceful and lawful enjoyment of their home. Excessive noise, unreasonable disturbances, or unsafe behavior are examples. 4. Discrimination. In rental housing, discrimination based on protected characteristics is a serious violation of tenant rights. Discrimination in housing applications, eviction practices, and other aspects of the rental process falls under this category. 5. Violation of maintenance obligations. An important duty of landlords is to make a property habitable and safe, which includes providing and repairing essential services like heat, water, and electricity. It is a violation if necessary repairs are not made or if safety issues are not addressed. Inability to provide essential services. Tenants must have access to essential services such as heat, water, and electricity provided by their landlords. 6. The refusal of essential services. It is illegal for a landlord to withhold services such as heat, water, or electricity, or interfere with their reasonable supply. Tenants' rights cannot be violated by landlords withholding or interfering with the supply of these essential services. 7. The illegal eviction of a tenant. Tenants cannot be evicted without a legal reason, and landlords must follow specific legal procedures outlined in the Residential Tenancy Act. For example, it is illegal for a landlord in Ontario to evict a tenant without following the proper legal procedures. You must provide valid reasons for eviction, serve proper notice, and obtain an eviction order from the Landlord and Tenant Board if the tenant does not voluntarily leave. It is illegal for landlords to physically remove tenants or change locks without a court-ordered eviction by a sheriff or bailiff. 10. Rent increases that are illegal or unreasonable. The Residential Tenancies Act requires landlords to follow rent increase guidelines. The landlord cannot raise rents beyond what is allowed by law or charge illegal fees. For example, in accordance with the Residential Tenancies Act, landlords must follow rent increase guidelines. The Landlord and Tenant Board must approve any rent increase in Ontario exceeding the guideline amount, and tenants must be given 90 days written notice. If a landlord issuing a new lease with higher rent without proper approval, he or she cannot charge illegal fees or force tenants into unlawful rent increases. 11. Refusal to return deposits. Landlords must return rent deposits and pay interest on them. In Ontario, landlords are required to return the tenant's rent deposit, which is typically used for the last month's rent, along with any accumulated interest. Additionally, landlords must pay interest on the rent deposit, typically equivalent to the province's guideline rent increase. Legal consequences can result if the deposit is not returned or interest is not paid. If interest is not paid, the landlord can either pay the interest directly to the tenant or add it to the rent deposit to cover any future rent increases. A tenant may deduct interest from their rent if the landlord fails to pay interest or apply to the Landlord and Tenant Board for an order landlord, requiring payment. 12. Retaliating against tenants for exercising their rights. In Canada, landlords violate tenants' rights by retaliating against them for exercising their legal rights. If motivated by the tenant's protected actions, these actions may include eviction, increased rent, or reduced services. In the event that you suspect your landlord has retaliated against you, you can file an application with the LTB in order to have your case heard and possibly seek redress. 13. A written tenancy agreement is not provided. Tenancy agreements may require a written copy from landlords in some cases. Most jurisdictions require landlords to provide tenants with a copy of their tenancy agreement, especially when using a standard lease form. A tenant may have specific recourse if a landlord fails to provide a written agreement, such as the right to withhold rent or, in some cases, to terminate the tenancy. 14. Violation of lease terms. Tenant rights can also be violated if specific clauses in the lease agreement are violated by the landlord. Essentially, any violation of specific lease clauses constitutes a breach of the lease, thereby violating tenant rights. Due to the fact that the lease agreement details both the landlord's and tenant's rights and responsibilities, any violation of these agreed-upon terms, whether major or minor, can lead to legal repercussions for the violating party. Tenants can do the following. As long as tenants understand their rights and take appropriate action, they can protect themselves from violations and ensure they are living in a safe and comfortable environment. The rules and procedures governing tenant rights and landlord responsibilities will vary by province and territory in Canada. 1. Document evidence. All communications with the landlord should be recorded, including dates, times, and details of any violations or incidents. 2. Landlord should be informed. Notify the landlord of the violation and request a resolution in writing and try to reach a solution. 3. Mediation is recommended. Mediation may be able to help find a solution if the issue is not resolved. 4. Get legal advice. A legal clinic or lawyer specializing in tenant rights might be able to provide guidance in complex cases. Advice and assistance can also be obtained from tenant rights organizations and legal aid clinics. 5. LTB complaint application. If direct mediation efforts do not lead to a resolution, tenants may file a formal complaint with the Landlord and Tenant Board or other relevant tribunals. 6. Complaint regarding human rights. Tenants can file a complaint with the Human Rights Commission if the violation involves discrimination. 7. Considerations to keep in mind. You should act quickly if you wish to file a complaint, since there may be a time limit.